last case of the day. I feel that I will not do justice to these names if I try to announce them. So if I could ask counsel, Ms. Carlson, you're going to give the opening remarks for 15 minutes and 5 minutes in your rebuttal. And Mr. Tsai, you'll have 20 minutes, and if you could give the name of the case when you come up, I'd appreciate it. Thank you.
Good afternoon, Your Honors. My name is Laura Carlson. I'm here on behalf of petitioners. Dilly Siufanua is how to say the last name.
Thank you.
And these parties are the grandparents to Layla, at the time of this originally going to court, a 9-year-old child who had lived with them for the better part of her 9 years of life. I think that's an important fact to consider and to keep in mind, because when this case went to adequate cause, it had been 16 days. 16 days to analyze what had happened over 9 years, during which time this little girl's father was gone, absent. Her mother was in and out of her life, and the only stable people in her life were her grandparents and her siblings, the people she called siblings, the children living in that home. Her grandparents were mom and dad. Those other children were brothers and sisters.
Counsel, can I just ask a couple of questions?
Yes, sure.
So that I can better understand this record? And is it correct to say that the mother's rights have not been terminated?
They have not been terminated. There was a concurrent modification case going on along at the same time between the parents. But her rights have not been terminated. She is still a parent with standing per a parenting plan.
And the mother's a party to this case, and the mother remains in the jurisdiction of Washington State.
She does, Your Honor.
And then second, I just had a question in regard to, is it true, or it appears that in the pleadings or in the briefing, that the parties had agreed to the appointment of a GAL?
They did. But because the case did not bypass adequate cause, one was not actually ever appointed. And so that's a point I like to make, that 16 days went by from the date of service until adequate cause was granted. And this child was told to pack a backpack and go to California, where she'd never been before with people she really did not know. Because 16 days did not afford the grandparents any time, really, to talk about what had happened with this person who had been absent for the better part of 9 years, who the last time they saw was facing charges for domestic violence for beating the child's mother while she was pregnant.
Counsel, let me come back now and ask a legal question.
Yes, ma'am.
So what's the showing that's needed to establish adequate cause?
For a non-parental custody petition, the showing that is needed is that either the parents are unfit or that neither of them is a suitable custodian for the child. And what our courts have defined that, what this court has defined that as, is that a parent may be unfit as one basis, or a parent may be fit, but placement with that parent, if it causes actual detriment, or could cause actual detriment, would also be a basis for non-parental custody.
And at what point does the court consider in making that decision the or of detriment to the child?
I believe at adequate cause, that is the part where it is to be determined. I think there is a big distinction, though, as to what is necessarily to be shown. For a long time, per Allen, for adequate cause, the standard has been facts which, if proven, would support a basis for non-parental custody at trial. And here, because it's only 16 days in, they did the best they could with what information they had. But more discovery would have been needed, more time would have been needed, and had they been allowed time, they're confident that they would have been able to show something more at trial.
Would they ask similar to a summary judgment hearing? Similar in the sense that you have to come with affidavits and proof at that point?
Yes, Your Honor. Similar, although it has followed a different legal path than a summary judgment motion, but it is similar that there hasn't been time to do much of anything. In 16 days, we don't even have discovery power. Can't depose any of the parties, can't ask for documents. Even professionals couldn't have time to get involved and really make an informed decision or informed recommendation about the child. So if anything, is there enough alleged at that hearing to say that these people should go to a trial?
Did they ask for more time, counsel? Did they ask for a continuance, or that they didn't have time to respond to the, it was their petition that was filed?
They did not ask for a continuance, if that is what the court is asking. They did ask for guardian ad litem and for the opportunity to provide more information, with the argument that this is an adequate cause threshold hearing that is just to, by law, make sure it's not a wasted hearing, which I think we can think of a lot of different ways that hearing could be wasted. It'd be abuse of the system for somebody to just say, I think me as the grandparent could do a better job than somebody else at parenting these children. Although I'd say 9 years without much.
There was some question that was raised as to whether the father had access to the child and what role the maternal grandparents played in allowing that. And at least for the first few years, the paternal grandparents seemed to have had involvement, and the father lived in the home with the maternal grandparents for the first year. So it's not really a case necessarily where the father was gone. And once the child support action was brought by the state, not by the mother or the grandparents, the father had been paying child support, and when he thought the mom was going into prison, he appeared to get the child, thinking the child would not have the mother with whom he thought she was living. So isn't all of that before the judge in making the determination as to whether there's adequate cause, as to whether a biological parent should not have custody of the child?
It was before the court, Your Honor, and also before the court was a couple of interesting facts. I don't know to what extent the judge took this into consideration because it's not part of her findings. The grandparents did not leave. They've lived in the same home for the better part of 30 years. So we're not talking about people who have moved around or tried to avoid him. In fact, at the point where the father did actually show up and say, I want my child right now, and I'm paraphrasing, he obviously knew where to go.
Well, was it clear that the mother was always residing there, or at different times was she in an apartment or other places? And was she in fact transitory from the grandparents' house, and at some of those times had the child with her and not with the grandparents?
No, the child stayed with her, with the grandparents. Child lived with the grandparents. There were times the mother came and went. She had some ongoing issues that never resolved as a result of the abusive relationship she had been in. But the child stayed put.
Did the father know that? And was the father given that information and allowed to have contact with the child, or the child contact with the father?
The father was never denied contact.
Well, the allegation was that actually the mother went down to where he was living and visited with him and his parents. They all had a visit, and a phone number was given, and the next day that phone number was no longer working, and so he had no way to reach the child again.
I understand that that's his allegation, but the evidence that the grandparents provided was that he knew where they were, because that's exactly where he left them. The child never left, the home never left, the phone number never changed. He was able to reach the child by Facebook, and in fact that was provided at adequate cause, which contradicts his own timeline as being represented to the court. His message to the child at that time says, it's been 5 years since I last saw you. 5 years from that date was when she was 1 year old. 5 years since I last saw you or heard your voice. And he doesn't say, I haven't been able to find you, I don't know where you are, I've been calling police. He just says, it's too bad, but I haven't seen you.
And Counsel, there's nothing in the record that indicates he didn't know the child was born but never, in fact, provided support. I mean, it's not like he didn't know he had a child.
No, he knew he had a child, and in fact, it was a couple years after child support was established by the state, paternity was established by the state, that he showed up at the grandparents' door. So he had at least a couple of years then where he could have done something. He had a court action where he could have requested visitation. He did nothing. It started collecting child support. but the bare minimum of effort was done. So if he really wanted to find the child, it would have taken very little effort. In fact, I think it did, because when he decided he did want to find her, he showed up at their door, and there she was.
Ms. Carlson, was there any request by the grandparents for visitation as an alternative request?
There is an order, actually, that was entered that provided for some minimal visitation. Although, because the record has continued after adequate cause was denied, that information is not entirely before this court. But they were allowed some visitation by court order.
So the appeal is actually from the denial of adequate cause, or the dismissal of the claim based on adequate cause. And you're saying matters have continued, including visitation.
Yes. I feel that if this were allowed to go to trial, there would be extensive information provided in addition to what was already provided before.
So if this doesn't continue, what would happen with the visitation order that's in place?
Well, it remains, I believe it's been challenged separately, but it's on its own path. It's still a valid order that was entered under the modification case, because those two, the modification case between the parents, sort of absorbed that order.
What's the standard that we apply to these types of review by the trial court denying adequate cause to go forward to a full hearing? What's the standard of review?
Well, for looking at the legal standard, it should be de novo, because whether the court got it.
Down below, counsel said it was abuse of discretion. Neither party argued it, and you didn't raise that on appeal.
It would be abuse of discretion was what the other part of what I was going to say.
Oh, I'm sorry.
Yes.
So, excuse me for interrupting. So say your answer again.
So it would be abuse of discretion in terms of the trial judge's application of the facts to the law. And I think the record shows that there wasn't much consideration by the trial court, despite the arguments being made, of the actual detriment that would happen with this situation. And I know the Court of Appeals relied on BMH, the custody of BMH, as finding that only children who have some sort of special needs really can fit that actual detriment prong. Although I can think of many instances where that may not be the case. For one thing, the way this case started didn't start how a lot of times what somebody would consider to do would be appropriate. For example, showing up saying, you know what, I've been gone all this time. I'd like to get to know my daughter. What do we do to transition to make this a good situation for her? At the same time, the grandparents would say, we don't even know who you are anymore. What's been going on with you? And that's what would have happened if we'd had more than 16 days.
Well, didn't he initially bring a motion to modify, and then it was your clients who later brought this action to have non-parental custody?
They were all filed within, I think, a few days of each other.
Right, but yours came after. Your clients came after.
I think just a few days after.
And didn't your clients also file something to bar contact completely between the father and the daughter?
There was an initial restraining order that was granted due to the nature of the way the father showed up. He showed up demanding. There was an altercation at the front door in front of the child where he was being verbally abusive without apparent concern for the fact that the child was right there. And so there was an initial restraining order entered to keep everybody separated and put some contact in place, but keep everything civil until there could be a full hearing. I mean, the last time these grandparents saw this person, he was physically abusive.
Can I follow up about the...
I want
Go ahead.
to ask a follow-up question. Are you talking about the allegation with their daughter, or are you talking about the allegation where there's disputed facts as to who was being abusive to whom at the time he was no longer in their lives?
So there was the initial charge where he was charged with domestic violence for beating her at the airport, and that was police records that were provided for the adequate cause hearing. There were descriptions of incidents that happened during that absent period where the grandfather actually had to intervene because of physical abuse that was happening right there. And then there's the way that Mr. Fuga showed up and actually, instead of calling, saying, I'd like to come see her and talk about transitioning, showed up, demanded that she come with him right now, and become verbally abusive to the grandparents in front of the child. And that's traumatizing. They described to the court that that was traumatizing to her, to have that happen so suddenly with nothing, no contact from him for years.
But the court heard that evidence and looking at what has to be shown for adequate cause, still ruled against your clients.
Yes.
And determined that it was not met in this case.
And there was some discussion about whether the judge was conflating the two prongs, whether he had to be unfit in order to show actual detriment. And the argument was, we believe that he could be unfit. Based just on the domestic violence. The allegation is that that behavior has not changed.
Well,
but nevertheless, placing this child with him, even if he is a fit parent, would be detrimental to her given the extremity of his absence and his behavior, not only while he was gone, but upon his return.
Thank you, counsel.
Mr. Tsai, could you just, because I would like to just get clarified what the answer was to the question posed, I think, by Justice Wiggins. So who has visitation? I guess I wasn't clear about who's where and where's the child.
Yes, Your Honor. I was not counsel for trial court for the third-party custody case, but I am counsel for the modification case between the actual parties, the biological parents. And so in the third-party custody case, there was, because of the fact that the court denied adequate cause, of course, that case was completely dismissed. However, in the temporary order, in the modification case for the paternity action, the grandparents were afforded some residential time in that temporary order. We have subsequently entered into a final parenting plan between the biological parents in the modification case. That parenting plan does not provide the grandparents with court-ordered residential time, but it does provide the mother with court-ordered residential time in which it's supervised by the grandparents because of the fact that she was incarcerated. So there is residential time that's being spent by the grandparents, but not pursuant to a court order, obviously in a third-party custody case because of the fact that the court denied adequate cause. I would like to frame the legal issue to the court today as when a non-biological parent files a petition for custody pursuant to RCW 2610, and they don't allege sufficient facts in support of their request for adequate cause, does the trial court then have the ability to be able to dismiss the case? Obviously, in about 2003, the legislature enacted the adequate cause requirement for a third-party custody case pursuant to RCW 2610. I believe that the language in that is very similar to what we would see in modification cases pursuant to RCW 2609-270. However, the legal standard, of course, is different because we're talking about a fundamental constitutional right. And I think that is the pervasive theme throughout this case that I would ask the court to be able to consider.
I'm considering the question as you have posed it, but what I'm struggling with is when a parent abandons a child for any length of time, and here we have a significant length of time relative to the child's age, how then does that not trigger an inquiry from the court to say, why shouldn't I at least allow some fact-finding on the question of whether any change would be detrimental to the child? It's not a determination of final custodial authority or visitation or residential placement. That's just a threshold adequate. Frankly, again, it's an adequate cause hearing. And I'm trying to struggle with why wouldn't a judge take a look at that prong that we have said is relevant?
Well, Your Honor, I think that the fact that the father was not involved in the child's life to the extent that, of course, he wanted to be for the duration of time is a different issue than the issue regarding whether or not the grandparents had met the legal standard by which the court would have the ability to be able to make a finding of adequate cause. And by that I mean one could assume that the duration of time that a parent is away from their child may cause some detriment to the child. could cause detriment to the child's growth and development, which is the legal standard, of course, that the trial judge in this case had to apply. However, that doesn't automatically mean that just because a parent was not with the child for a specific period of time, that automatically is going to meet that particular prong. The requirement that has clearly been set forth in the cases that have come down in the progeny of the cases with respect to third-party custody indicate that there has to be some detrimental aspect that would impact the child's growth and development, because that fundamental right, Constitution-protected right of a child to be with a biological parent is so strong. And that's really the key to this case, I think, in terms of what we're looking at regarding why the trial court said, yeah, I understand. And if you read the transcript of the findings from the trial court, I mean, the trial court judge was very cognizant of the fact that this was going to be a difficult thing for this child to be able to, transition between the grandparents' residence and the biological father's residence. However, the judge indicated that while it would be difficult for the child, because there's been no indication from the grandparents that this child has some extraordinary circumstances, some special need that the biological parent would not be able to fulfill, then the trial court properly followed the law and dismissed the case. I don't think that just the fact that the father was away from the child, and we could discuss, of course, the reasons for that. I mean, he was threatened by the paternal grandfather. In the record, it indicates that the paternal grandfather had actually punched him in the face, threatened his life if he came around his daughter and the child again. And of course, Mr. Fuga was young and he was establishing himself. But I think that the most important fact that, of course, that the trial court had in front of it with respect to Mr. Fuga was that he had a very stable family life. He had remarried. He had children who were 4 and 5 years old.
You're avoiding the concern that I have, and that is, again, the detriment to the child. Let's just assume, for purposes of this discussion, that he's a fine man and he might be a good father, and that the reason he left might have been even a good reason. But I'm just wondering, how do I understand or reconcile that no inquiry is made into the impact that this may have on the child at this point? This, I think we all know children are no longer a commodity or seen as property. I mean, they're little people with personalities, with development issues. And so I'm just wondering, why wasn't that inquiry made, and why should I not be concerned about that?
Well, Your Honor, it's not that the inquiry wasn't necessarily made, and I think that I would respond to that by saying that how it is that the case came before the court is determinative in terms of that. I mean, what I would say is this, is that the child had been primarily residing with the grandparents for a certain period of time. I think the period of time somewhat is in dispute regarding the facts as to whether the mother was with the child in an apartment for a period of time that the paternal grandparents had been spending time. But the fact is that in the grandparents had the child, and so had the grandparents, with all of the facts that they know about the child, had indicated in their affidavits in support of adequate cause, this child has this, and this, that would make it so that even if the court makes a determination that Mr. Fuga is a fit parent, that he still wouldn't be able to meet the needs of that child because of these reasons. And so certainly they were afforded the deference with respect to having custody of the child and the facts that would be in support of that.
I understand your answer. So when the court's doing the initial inquiry, do you look at the father and say, well, he's got 2 kids, he's parenting them just fine, he's a fit parent, and the inquiry is done? Or do you look at that and you also say, and there's a child, that we have to evaluate her situation, not having had contact for 7 or 9 years or whatever the duration is. So let's see what that would look like and have a guardian ad litem tell us how she might adjust to that transition. So do we end at that first part, or do we do the second part?
It's 2 parts, Your Honor, of course. I don't know if I would go as far as saying that we need to appoint a guardian ad litem to be able to do a fact-finding inquiry in terms of that. I think that one of the reasons why it is that the adequate cause determination and threshold has been established is to be able to avoid that if it's not going to be necessary.
I think I'm understanding your answer to be, once we know that the father is able to parent another child, then we just say, does this child have special needs? And if there aren't special needs, then the inquiry is over.
Well, somewhat, Your Honor. I would say this, is that I think that the cases that have indicated what the standard is with respect to adequate cause, being able to prove that, are consistent with the judge's ruling in this case. There were no facts that were alleged by the grandparents that there was any special need or other extraordinary circumstance, which is the standard of the law, regarding care of this child.
Well,
And
can't an extraordinary circumstance be the fact that the child was separated for so many years that there's absolutely no bond? I mean, wouldn't that be a special circumstance? And I'm not, because it seems to me that if you're saying special need can't also include special circumstances, I'm not sure why you would draw that distinction.
Well, I think, Your Honor, that special circumstances would be the higher, I would look at it in terms of hierarchy, and that the special need of a child would fall under the special circumstances. It doesn't necessarily have to be a special need that the child has, but there definitely has to be some type of extraordinary special circumstance to grant a third-party custody case.
And isn't the fact of so many years in separation with no ability to bond because of what, no fault, I'm not saying whose fault it is, but if that's not there, why isn't that at least worth exploring as a special circumstance?
Well, Your Honor, in this particular case, there was a visit that took place in 2012 with the child, and a very descriptive colloquy regarding what happened. The child ran to the father and said, Daddy, Daddy, what's your favorite color? What foods do you eat? I mean, wouldn't leave the father's side in terms of that, which was uncontroverted with respect to the evidence that was submitted to the trial judge. So in this particular case, of course, the child was even though the child had not spent a lot of time with the father, and I think that this is kind of why the law is that you have to take every factual scenario, pursuant to its own merits, as opposed to more general. In this particular case, this child knew who the father was, expressed a significant bond and love for the child, despite the fact that there was a significant period of time that had gone by in which the child was not spending regular residential time, with the father. So I think that, that under those circumstances, and the trial judge, of course, is going to be taking in consideration the allegations that are being made in the affidavit submitted by the grandparents, but of course also considering the father's, current circumstances as well. I think that the court did make a determination that, he was gainfully employed, had been gainfully employed for a substantial period of time, had remarried and had 2 other children. And then, of course, this bond that had been expressed by the child, to the father during this visit that took place in 2012.
If I could interrupt you for just a second here. So let's suppose the judge had held a hearing, had said there's adequate cause, that it proceeded to a trial, and then the judge said, well, at the conclusion of the trial, the judge said, well, I find there really is no substantial bond here. The child has lived away from the father for so long. The child has not really had much history with the father's new family, has never really lived in California. I think that this is sufficient to grant custody to the grandparents. Would that be a viable theory? I mean, would this court say there's not sufficient evidence, or would the court say there is sufficient evidence?
Your Honor, what you described to me makes me think that the court would be applying a best interest of the child standard to that kind of situation, instead of the actual legal standard, which is going to be actual detriment to the child's growth and development. And so the fact that the child may, in your example, may not have a bond at that particular time doesn't rise to the level in which that there would be actual harm to the child's growth and development necessarily. Certainly the bond, if it didn't exist, could be fostered, and there could be ways to be able to facilitate that.
And that's something you could really only dig out at trial, isn't it? I mean, those types of considerations, foresee the future, really dig into the nature of the child's bond with the grandparents as well as with the father.
Certainly there would be a lot more facts, Your Honor, before the court at a trial in which discovery had been completed and so forth. But would that trial in this case be necessary for this particular child? And my answer to that would be no. And the reason for that is because the father was a fit parent and the grandparents were unable to be able to show to the court that there was any actual detriment to the child's growth and development if the child was to be with the biological father.
I guess this goes to the question of what really do we mean when we say adequate cause. When we say that, do we mean, yes, looking at all the evidence at the show cause hearing, this is the way I would rule, I would give the child to the grandparents, and then you proceed to trial and decide whether that was right or wrong? Or what does it really mean to say there's adequate cause under the statute?
Your Honor, the definition of the adequate cause, the burden of proof, of course, is to be able to show that either a parent is not fit, or if the parent is fit, that it would be detrimental to the child's growth and development to be able to provide custody to the biological parent. Does the third-party custody petitioner have to prove that in the adequate cause hearing? No. But does the petitioner have to provide sufficient evidence to be able to show that each one of the allegations, that there would be sufficient evidence to be able to show that? In terms of the adequate cause determination for a 2609-270 action in a modification proceeding where the standard of law is the best interest of the child, language is as showing sufficient to support a finding on each act that the moving party must prove to prevail. And that is really kind of the guidance that the courts have provided us with respect to how to make a determination regarding the adequate cause. What was wholly missing in this case, and why the trial judge properly dismissed it, was any contention that there was an extraordinary circumstance that would make it so that the biological parent could not take care of the child. And that's really the inquiry that was drawn out with respect to that. And again, while it was argued that there was insufficient time to be able to present their case at the adequate cause hearing, I do not believe there's anything in the record with respect to a request for a continuance or fact-finding or ability to perform depositions or anything like that.
Let me ask you about that, though, because a large part of the discussion at the time of the revision is about everybody agreed to a GAL. This home visit isn't enough. We need to get more facts about what the situation would look like from the child's perspective. We need the GAL. It's not a continuance request, I understand, but certainly a request that the judge allow some fact-gathering through the GAL. What about that?
Your Honor, I wasn't the counsel of record at the trial court, and so the way it was explained to me was that if the court appoints a guardian ad litem, this is who it is that we would agree to, which is not the same as saying we agree to appoint a guardian ad litem.
Okay, so well, I'm not really focusing on whether it was agreed or not. What I'm saying is a large part of the argument to the Superior Court was we need a GAL to find out what this is really going to be like. Can't you appoint that? The court seemed concerned about the cost of that, recognizing that this wasn't a divorce case, the parties were not in equal standing, that it was the grandparents' burden. But the court does reference, at one point, I could find the page, she says, part of the reason we don't want to do that is it's very expensive.
That was part of the record, Your Honor. That is correct. However, I think that if the trial judge believed that there was sufficient evidence to be able to proceed, which is normally how it is that we would look at this, is that once you have a determination that there is adequate cause, and then of course there's an open case, you would appoint a guardian ad litem to be able to investigate and move forward towards the trial. But the law is that you first have to be able to meet that threshold. You have to meet the adequate cause determination to be able to proceed and get the guardian ad litem on board. And in this case, the trial judge looked at the applicable facts, looked at the affidavits that were provided by the grandparents to make that determination. Is this a case in which I find that the father is fit, and if the father is fit based on the evidence that was submitted on the affidavits, is there any special need or other extraordinary circumstance that would apply to this particular child regarding the biological father's ability to care for the child? And the answer to that question was no. The father does have the ability, willingness, and had shown through his affidavits and evidence that he was fully capable of taking care of all the child's needs.
Let me ask this, though, and I do understand this isn't like a primary placement decision, or this is a unique proceeding because the parties don't stand in equal status. But from a legal argument point of view, is your argument that if the dad is in a stable home, is caring for other children, is responsible to care for the child, that those are the relevant considerations? Is the court allowed to consider how that would affect the child emotionally?
The court can always consider how any particular action would affect the child emotionally. However, from my perspective, it's kind of, you have to look at both sides. So you look at the father to make a determination, is he fit? And in that same determination as to whether or not you're determining whether he's fit or not, you can consider whether or not he would be able to take care of a child who might have a special need, for example. I mean, that's part of the inquiry regarding making a determination as to the father and how the father is functioning and so forth when it relates to his ability to be able to take care of the child. But of course, the inquiry doesn't end there. The inquiry then has to go to, and I'm not saying that this is the order in which it would take place either, but the inquiry has to be, is there a contention that the father is unfit? And is there a contention that this child has some extraordinary circumstance that the biological father would not be able to care for?
No, I thought the finding of the court was quite clear. This is a fit parent. Nobody makes it. The mother is unfit, I think is the finding, but the father is not unfit. So we're just in the actual detriment portion. So my question is, how does a party in this kind of context come in with sufficient facts of that, short of, if this were in a different kind of proceeding, a court might appoint a GAL to get inside, get behind the veil. You've got to get in the family relationship and spend time with the child and figure out what's what. How does a party petitioning for third-party custody do that without a GAL?
Well, they would be able to supply evidence to the court. For example, if Leela in this case had specifically had, emotional problems related to, the absence of her father, for example, that could have been something that would have been stated in the declaration submitted to the court. If the child had educational problems or something for that matter, that could be something as well. But, Your Honor, in this case, the child had missed, I believe it was 19 days of school for the school year prior to the grandparents when they said that they were caring for the child. 19 days missing from school and 17 tardies because of the fact that the grandparents were just simply not getting the child to school. The letters from the school that were provided were before the trial judge said specifically, this is impacting this child's ability to be able to have a proper education because of the fact that the child is simply not here. So, but in answer to your question, certainly the grandparents could have set forth facts that would have been sufficient to meet the standard of adequate cause, consistent with the law regarding depriving a biological parent's fundamental right to their child. Thank you, Your Honor.
Your Honors, I think the important thing to remember is that this was an adequate cause hearing. It wasn't a trial. And according to custody of EATW, and I'm going to quote, the adequate cause standard is factual allegations that, if proved, would establish that the parent is unfit or the child would suffer actual detriment if placed with the parent. After 16 days and a father who's been absent for that many years, I don't know how you could argue actual detriment other than what they did, which is to say, we don't know this person. The last time he was here, he was violent and charged with domestic violence. Every time we've interacted with him, he's been violent and angry. The way he showed up was violent and angry. 9 years of her life, 8 years gone. That warrants a pause long enough to have a professional involved. And maybe that professional comes back and says, you know what, I think we need a transition period, but then it would be fine. At least we would have an informed decision then. Maybe a professional comes back and says he's not being honest. This domestic violence issue is still continuing in California, which I'll note is an extra difficulty when you have 16 days to go to court and another state. We don't have JIS or a similar system just to pull up and look and see what's been going on in his life. We don't have an opportunity for somebody to go and check everything out to see if what he's saying is true. That's what would have happened if we'd been able to proceed with the guardian ad litem and trial. Counsel talks about something extra being needed. And I think he references extraordinary circumstances. I think that so many years with a minimal bond not only raises a question about what's going on with this child as to why her father's not there, but how does she feel about him coming back? Special needs, extraordinary circumstances can arise based on traumatic experiences. These grandparents described that how he arrived was traumatic. Being told to pack a backpack was traumatic. So there's no way that we could stand here and say, well, we think this would be detrimental to her because we think it would be detrimental to any child to be yanked away from the only home they've ever known and placed with somebody who is pretty much a complete stranger. And then to find that he's had this whole other family and this whole other life all this time and hasn't done anything to try to fight for her until now. It warrants a further look. And a guardian ad litem should have been appointed. There should have been some consideration of professionals so that there could have been some discovery, fact-finding, and fully informed information provided to the court. And that just can't happen after 16 days. And I mean, it literally cannot happen. We don't have discovery power even at that point.
What is your view, counsel, of any interplay between the parenting plan and the third-party custody petition? And I asked that, what if the parents got together and agreed to modification of the parenting plan? And there was no, in this case, would the third-party custody action be appropriate?
I guess the
reason I asked that is mom has not been declared unfit.
Well, mom was in jail, so she was just not an option. And so going forward, she has an independent basis after being released from jail to go forward to try to modify the parenting plan. But I don't know that the grandparents could refile a new petition. They no longer have the child with them. So they would still be facing the same difficulties as before. Of course, the parties, if they completely change, they could enter an order about visitation, but I don't know that that's going to happen, considering that the current one has taken steps backwards from that.
Can I ask, though, in the petition proceeding, this proceeding, I thought there was a factual finding by the trial court that the mom was unfit currently.
I believe that there probably is one as of
I thought it was
the
in the handwritten findings in the order.
She was at least found to be unavailable because she was in jail, so I don't think there was really much discussion about what she could do otherwise.
Thank you, counsel.
Thank you.
The court is going to go into recess.